Greetings, my fellow Americans, and welcome to yet another episode of the Great Montana Conspiracy Podcast. I will apologize in advance. I'm still fighting a cold, so if I cough, if I in the middle of it, just forgive and just bear with me as I proceed. I wanted to make sure I made this video on time, so therefore, here I am. Tonight we're going to deal with something I've been talking about quite a bit in my other videos. I keep saying that I'm going to talk about it. It's another subject for another podcast. Well, here it is. We're going to talk about double jeopardy. Double jeopardy is a pretty simple term. Most people should recognize what it is. No person can be held to double jeopardy under American law. It's in every state constitution. It's in our federal constitution. In fact, the language is just so explicit that there's really no question that it exists. But not everybody understands what double jeopardy is, which is where the government's allowed to kind of fudge the areas a bit and just proceed as if they know what they're talking about and no one objects, and therefore they just keep doing it. Montana is no different. In fact, Montana is probably about 20 times worse than most other states. They take an exception that someone else says, hey, here's a little niche we can use, and they run with it completely the other direction. So let's talk about that for a bit. First of all, let's understand what double jeopardy is. Okay? By the Fifth Amendment of the United States Constitution, it reads, and I'm going to read it verbatim, nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. The Montana Constitution, in Article 2, Section 25, reads, no person shall be again put in jeopardy for the same offense previously tried in any jurisdiction. There you go. It's right there. It exists. Now, I can tell you what double jeopardy is, but why don't I let the U.S. Supreme Court answer that question? In a case called Brown v. Ohio, which, for reference, is 432 U.S. 161, it's a 1977 case, they summarized the standard of double jeopardy. By their terminology, double jeopardy has long been defined by three principles. It protects against a second prosecution for the same offense after acquittal, which is what most people see double jeopardy as, by the way. It protects against a second prosecution for the same offense after conviction. In other words, if you're convicted of the crime, they can't come back and try you again for it and just keep doubling down on it. The third area, and the area that most people simply do not know exists, and it protects against multiple punishments for the same offense. There's a huge, huge area in American law and criminal contempt issues that everyone seems to overlook. Every time a court says you will serve 50 days in jail and a $100 fine, that's double jeopardy. That's two punishments for the same crime. It's become so standard to just add and tack on all these additional penalties that nobody even thinks about it. It's just practice. Everyone accepts it. It is the way it is. And therefore, nobody asks questions about it. But there it is. The United States Supreme Court in Brown v. Ohio says it protects against multiple punishments for the same offense. You can be punished once for your crime. You cannot continuously and repeatedly be badgered down with multiple penalties. That's what the Constitution says. That's what the United States Supreme Court said in 1977. And that's a practice that's been inherent in our country since the very beginning. They simply defined it in a very nice, neat package. Here's a nice little pretty bow to put on top of it. But the problem is that nobody cares because nobody is informed enough to recognize that critical area of the law. And every law in the states exists as a foundation of their constitutions, and every foundation of the Constitution exists upon the federal Constitution. The United States Constitution is the foundation of all law in our country. No law can exist without it. No judge can issue a statutory rule. No legislature can do it. No president can. Without the Constitution, there can be no law because it gives the foundation of law in our country. And if our Constitution says you cannot do this, and the Supreme Court has interpreted that is what the Constitution says, then you can't do it. But all those minuscule issues aside, what happens when a government decides they're literally going to take someone's life and worry it away with repeated over and over and over again, returning the same penalty to you over and over and over again. What happens when you get a 10-year sentence, and before your 10-year sentence can be up, they renew the 10-year sentence. And before that 10-year sentence can be up, they'll renew it again, and renew it again. Now, you've served your 80 years or however long your lifespan left, and you die. Because the courts simply keep you in this perpetual loop forever and ever and ever and ever. And that is what Montana was doing. And it can still do it. It has the power to still do it. And this is an important aspect because they made a big to-do a few years ago in 2017 about changing the law. I'm not sure why they changed the law when they did. I know I certainly was raising the issue in the United States Supreme Court at the time, that it was starting to be buzzed around. They changed it effectively in 2017. I was raising it in the U.S. Supreme Court in 2015. Our legislature only meets every 2 years. So it's in that window there. I don't know whether my raising it caused an issue, whether somebody else was raising it. Somebody saw the loophole and said, oh, wait a minute, this is a problem. We need to fix it. They didn't really fix it. They just hit it. They hit it better. And I'll get into that later in this podcast. But the thing is, Montana routinely subjects anyone prosecuted here to double jeopardy. And I'm not talking about the imposition of fines and everything else and multiple. And I mean, you look at a sentence in Montana and it reads, the following penalty, A, B, C, D, E, F, G, H, I, and they're just like 20 lines of different penalties. Different fines, different restitutions, different consequences, different limitations, different restrictions, all massed together under one order for one crime. Multiple punishments, people. Multiple punishments for the same offense. You can give someone prison time. You can fine someone. You can't do both. Not by the Constitution. Not when the Constitution says you can't. But the justice system is just so corrupted about getting power and doing whatever it wants to do without restriction. Nobody pays attention to that little aspect of law. And the big issue I'm talking about, though, is how Montana uses suspended and probation sentences. Now, in modern times, as prosecutions and the prosecutorial governments, and this isn't just true in Montana, but it's true elsewhere, suspended and probationary time have largely become synonymous only because of the way they're practiced. And that's an important aspect. Practice, not what the words mean. Okay? The words mean completely different things. But because prosecutors have not been stopped from doing it, just the same ways they're not stopped from doing the multiple penalty phase of a criminal offense, they're not stopped from doing this. Montana took it a huge step further, and I'll explain that in a minute. But a suspended time, and by the way, I'm going to read you the definition from Black's Law Dictionary, 9th edition, okay? A suspended sentence is a sentence postponed so that the convicted criminal is not required to serve time unless he or she commits another crime. Pretty simple, right? The suspended time says if you go out in the community and you remain law-abiding, you never have to worry about this penalty. You committed a crime, though. If you become a persistent criminal offender, we can give this time back to you. We can reimpose this time on you if you committed a crime. Doesn't matter what crime. Doesn't matter. It could be a misdemeanor. You could jaywalk. That's how diverse it is. Jaywalk, be a felony, go out and murder somebody, whatever. You commit a new crime, they can give you the time back. A probation sentence is a court-imposed criminal sentence that, subject to stated conditions, releases a convicted person into the community instead of sending the criminal to jail or prison. Now, this is the important part. Also, one thing to keep in mind, probation and parole are primarily synonymous. The only difference between a probation sentence and a parole sentence is that a probation sentence is a direct release ordered by the court. Parole is typically released when they're already in custody in prison, and the parole board or some other agency determines they're entitled to an early release. So they're released into the community under probationary conditions, but their actual release is termed parole. But as far as the judicial decisions, they're synonymous. Any rule that applies to parole applies to probation. They're both supervised release conditions. They're both forms of custody, and they're both identical forms of custody. Just as one is triggered through a different element, but the end result is the same. So when the courts refer to a parole custody, It's the same thing as talking about probation custody because there is no difference. There is no difference. Now, the reason why I bring all this up, the suspended sentence, and this is the important part, a suspended sentence is a sentence that is not served at the time it's imposed. That's an important condition. By the way, that was the definition from Black's Law, 8th edition. A probationary sentence is a sentence that is served in lieu of custody. Again, that's a Black's Law Dictionary, 8th edition definition. The important distinction here, one sentence is served, the other is not served. Because a probationary sentence is served, you get credit for all your time you serve on a probationary sentence. If you have a 5-year probation sentence, 5 years, and you come out and do 3 and you violate, they can't give you back all 5 years because they have to give you credit for the time served. You've served 3 years in custody supervision. It's community-based custody, but it's still custody. You're still subject to restrictions, to restraints, to limitations. You're still subject to having your home invaded and searched whenever they want to. You're in custody. You belong to the state. You're just being held in a community instead of in a jail cell. A suspended sentence, because it is not served, can be given back to you in full. If you go out on a suspended sentence and you serve and you commit a new crime after 3 years, they can give you all 5 years back. All 5, not just the 2 that's remaining, all 5, because you're not in custody. Now, as I've said, in modern day jurisprudence, with the prosecutions moving the way they are, they're trying to merge these terms and make them synonymous. They're trying to get the general public to accept that a suspended sentence is a form of probation. No, a suspended sentence is supposed to be suspended. Suspended, not served alternatively. Under the modern interpretation that the courts want, or the prosecutors want the general public to see, they want to see that suspended sentences and probationary sentences are identical because they both are subject to probation supervision. They're not. They're not supposed to be. A suspended sentence is not served. You're not supposed to serve any kind of custody in a suspended sentence. For instance, in my case, I had a 20-year sentence, 5 years Montana State Prison, 15 years suspended. So that should mean after the 5 years, I have 15 years in which I have to remain law-abiding in order not to get any more time back. But I should be released to the community. Instead, the Department of Corrections determined I need to be released to probationary custody. I argued that in court. Of course, as always, the Montana Supreme Court refused to rule in my favor, either ignored the issue or simply issued unpublished opinions, which I've talked about in other videos as well. Now, in Montana, the law used to be much more draconian. It literally permitted open-ended revocations, and this is how it used to work. And it still does work this way, by the way. It's just they've hidden it better. You're serving a probation sentence and a suspended sentence, and the state requires you to do both. During any suspended period, you are under the supervision of the Department of Probation and Parole, not the Department of Suspension, Probation, and Parole. Under the Department of Probation and Parole, you are required to serve supervised probationary custody. Okay, there's no other way to look at it. As I said, this is not the Department of Suspension, Probation, and Parole. It is Department of Probation and Parole. They're not supposed to have jurisdiction over anyone with a suspended sentence. Yet the legislature decided they wanted suspended people to be on probation. Why? Because the state gets money for it, of course. It always comes down to money. But because a suspended sentence is not the same as a probationary sentence, they're treated as 2 separate, simultaneously running sentences. And how Flathead County used to do it, almost universally, they do it less now because the language has been changed, but again, I'll explain how that's still detrimental today. The original language of the law, which is, by the way, if you want to look it up, it's MCA Montana Code Annotated 46-18-203 paragraph 7, subparagraph B. Okay? The original language of this law, up through 2017, read, a judge may revoke the suspension of sentence and require the offender to serve either the sentence imposed or any sentence that could have been imposed that does not include a longer imprisonment or commitment term than the original sentence. In layman's terms, if you got revoked on your suspended sentence, they could give you your entire probationary sentence, or on probation, they could give your entire suspended sentence back to you. Remember, probation is a form of custody. You're serving a sentence. You're serving under custodial supervision. It's not just free time. You're not out there doing nothing. But they get to give it back to you, all of it, because they consider the probation violation a crime. It's a misdemeanor, but it's a crime. A probation violation is a crime, and therefore, under the extended belief that if you don't remain law-abiding, you get to have all your suspended time given back to you, they would literally have people serve 9 years of their 10-year sentence, violate them, and give them their entire 10 years back, put them back out on probation for another 10 years. My brother's a perfect example. He kept going through the repeating cycle of just constantly, I think he got violated twice. He got sent back to prison, got his time extended over and over and over again. Because, and don't get me wrong, my brother's not an angel. My brother does have criminal tendencies. He's an addict. I don't say that to be mean. I don't say it to be a slur of any kind. He's an addict. He has a problem. Right now, he's in custody. Right now, he is hopefully on his way to a treatment facility in Washington, which I am very hopeful will prove beneficial to him and will turn his life around so he can actually become a more positive person and can break his addiction cycle. But he has committed crimes. I'm not going to just whitewash that. That is the truth. That is the absolute flat truth. But if you're serving a suspended sentence, you should not get that time back unless, if you're serving a probationary sentence, you should not get that time back. Simultaneous double jeopardy. 2 simultaneous sentences running at the same time, a suspended sentence and a probation sentence. They use a probation sentence to say you're violated the terms of probation, and they use the penalty phase of the suspended sentence to give you all your time back. Now, as I mentioned, they changed the law in 2017. But it didn't really change it. What it did was it hid the language better. And I will read you the current language. The current language is, if the judge determines that elapsed time should not be credited, the judge shall state the reasons for the determination in the order. There's a preceding part to it that actually says that the judge should consider time served under supervision and give credit. But then it turns around with this exact statement and says, if the judge determines that elapsed time should not be credited, the judge shall state the reasons for the determination in the order. There is no criteria of guidelines to say what reason. Joe Bob had brown hair, and therefore I don't think he deserves to have. That's literally how vague that is. Anything, any reason. I didn't get my Wheaties this morning, and I don't feel like being generous. All he has to do is just say his reasons. He doesn't have to have a legitimate reason. Just state the reasons. Now, of course, the state Supreme Court can always go back and determine it, but anyone listening to this podcast for any length of time understands my feelings about how likely that is. It's very rare for the state Supreme Court to overrule anything, regardless of how ridiculously stupid the district court rulings are. So that's not likely to happen. But the language is there. It hides it better. It gives a preliminary set where it says that supervised time should be credited. But then it turns around and gives the judge the authority to just ignore that completely without even a real guideline or set of foundation or rules by which they have to do it. Like if they did this, that, or the other. If they, I don't know. If the violation has to do with an underlying element of their crime, as an example. Or they were not really serving, they fraudulently served the time and that they had somebody else signing their paperwork and turning it in. something that would indicate they hadn't actually served their time. I'm just spitballing here. But that's just it. There are no guidelines. All the requirement is if the judge determines the elapsed time should not be credited, the judge shall state the reasons. So he can still give you all your time back. That 10-year sentence can still be given back to you in full because the judge wants to. Now, as I mentioned, this is a penalty phase. Now, if you go online, I've of course, whenever I do these podcasts, I do my research. I go out, I try to find out what other people are saying. And there's several places I found where people without any kind of legal authority state openly that probation is not a form of custody because they think that you're out in the community, they think you're out there under supervision, you're fine, you're not in custody. Not true. The courts have consistently come back and said that probation and parole are forms of custody. The United States Supreme Court has consistently come back and said that. There's a case in 1923, Anderson v. Corral, 263 U.S. 193. And I guess I should explain again, that is the 263rd volume of the U.S. Supreme Court's cases, page 193, 1923 case. The court stated that while parole is an amelioration of punishment, it is in effect punishment. In other words, it may be setting aside the actual confinement, but it's still punishment. So you don't get to sit here and say it's not custodial, because it absolutely is. It's custodial. It is. It's just no other way to look at it. And for that purpose, let's look at another case, a 1963 case. Persons on parole, probation, or bail may be in custody for purposes of Section 2241 and 2254, which are the statutes under the federal guidelines for habeas corpus. That is a case called Jones v. Cunningham, 371 U.S. 236. It's a 1963 case. Individual on parole applied for habeas corpus. The U.S. Supreme Court determined they were in custody. When you have these people out here who want to put their opinions on out here, great, wonderful, fantastic. Back it up. That's all I ask. Back it up. I'm backing it up. I'm giving you U.S. Supreme Court cases right here. I'm giving you doctrine. I'm giving you constitutional law. I'm giving you the state laws. I'm backing up what I'm saying. If you think different, at least make the effort to try to present fact, not just opinion. Because it makes it incredibly hard to sit here and go, well, what are you relying on? What basis? I'm not going to quote you or cite you if you can't give me an authority. And I'll gladly change my mind. You can convince me, convince me. But at least try to, back up what you're saying with some authority. That's all I ask. Because people are just so easily swayed today. Let's face it. We had an entire QAnon phenomenon that believed that Trump was the second coming, who was ascribed by God to hunt out sex traffickers in the Democratic Party and the Supreme Court. I mean, and people believe this. We have actual representatives who were elected to Congress who believe this QAnon conspiracy theory. And let's not forget about Pizzagate. Look it up. I'm not going to go into detail here because it's just too long of a story, but it's a funny story. Maybe I'll do a podcast on that, just because it's a funny story. Just how insane these conspiracy theory goes and how people actually believe these things. But, I mean, just as an example, as we're talking about the double jeopardy issues, we're going to take a look at my own case. And I was released I served 5 years in prison, my full 5 years, because I refused to confess to a crime I didn't commit. The only reason the parole board would not release me, they wanted me to complete a program wherein I confessed to the crime. Again, I can show you mountains of judiciary cases from the U.S. Supreme Court that says that the right against self-incrimination survives post-conviction. Show you mounds of it another time, because if I sat here and rattled off every piece of information I had and went into deep depth on every issue, these things would be like 3 hours long. And let's face it, My attention span isn't that long. So, but I'm going to say in my own case, I served from 2004 to 2009. I was released to the Department of Corrections custody. Again, 20 years, 5 in Montana State Prison, 15 years suspended. There were terms of probation and parole set in my sentencing judgment, but no term of probation. But Montana says he's going into probation anyway. So I'm into custody of probation. The original probation officer I had, Dave Edwards, which if you do a search online, you'll find out I sued him, took it all the way to the district court, trial, everything else. Total, it was a mess. It was a real mess, but it's a subject for, again, massive subject for another podcast. But in the particular case that started it, when I got released, one of the first things that Dave Edwards tried to do is revoke me. He tried to revoke me because I filed a habeas corpus, challenging release. He told me literally across the table, said, if you file one more legal action, you're going to prison. The conversation went like this. He said, you need to stop filing legal actions. And I said, Dave, if you were accused, he says, don't file any more appeals, don't file any more restrictions, just stop with the legal actions. Stop it. You don't need to work, you don't need to do any of that. I said, Dave, if you were accused of a crime, a heinous crime which you did not commit, it was going to overshadow you for the rest of your life, at what point would you stop fighting? His response was, at the point where I'd be going back to prison, which is where you're going if you file one more action in court. I immediately went home and filed for a habeas corpus. 2 days later, they were trying to revoke me. The revocation failed, thankfully. His primary, keep in mind, I was out of prison by 6 weeks. We're in the middle of a recession. And I had not yet received my Social Security. I had started the application process. I actually was working with Voc Rehab, trying to find alternative forms of employment under the incredibly restrictive guidelines that Dave Edwards has put down on me, which are even far and above beyond, which again I'll be going into in a little bit. But he sat here and threatened me and then tried to revoke me because I tried to file a habeas corpus challenging my custody. Spent 6 weeks in jail for it. They released me because my Social Security came through, because Dave Edwards was stupid enough to call the Social Security office and tell them where it was. If he hadn't done that, I would not have received the letter that told me they basically needed one more form signed, and they were granting my case. Pretty simple. Sign one more form. If I hadn't signed it, I wouldn't have it. Well, since his primary form of his rested upon my inability to cover costs and not seek employment and blah, 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 his revocation fell apart. Well, he didn't like that. So he kept trying to impose conditions on me. Well, keep in mind, not legal. The Department of Correction has no authority to impose new conditions on you. There's a whole host of cases. There's State versus Field, which is, for the record, is 11 Pacific 3rd, 1203-2000. It's a Montana case issued by Montana court justices in the Montana Supreme Court. And it says, a judge cannot delegate his sentencing power to the Department of Correction or any other agency. Then there's State versus Hatfield, which is 846 Pacific 2nd, page 1025, which says that the judge cannot grant its authority to the DOC to create subsequent modifications, to add additional elements. State versus Hanners, which is 839 Pacific 2nd, 1267. Sentence cannot be modified by the Department of Corrections. I mean, the list just goes on and on and on. I just grabbed 3 cases because I knew I was going to have to cite them in this podcast. But the state's own decisions say they can't do this, but the Department of Corrections does it all the time, and they did it to me consistently. Told me I couldn't go to restaurants. Told me I could not go to my physical rehabilitation. Told me I could not go. He wanted me to not to go any place where there was a reasonable expectation children could be present. He had all these expectations he wanted of me. I said, those are not my conditions, Dave. Those are not my conditions. My conditions are set there in black and white. I'm your probation officer, and you have to do what I tell you to do. No. I have to do what the court tells me to do, and you're supposed to supervise me. And we'd have these back and forth banterings because I refused to bend. And and more than once he says, open your mouth one more time, I'll revoke you. Argue with me one more time, and I'll revoke you. Just because I disagree with how he was doing it. So he tried to get me to sign a modification, a whole new list of rules, which would basically delegate me a level 3 sex offender. Or sorry, there's level 1, 2, and 3. There are no level 0s. Level 3 is the most egregious and has the most restrictions upon supervision. He wanted me to sign an agreement to basically adhere to level 3 restrictions when my classification is a level 1. And level 1 is the absolute lowest. And honestly, if there was a level 0 in the test, I would have tested level 0 because I am not a sex offender. But there is no level 0. This test is literally, that's another subject for another time. It's a trap. Do not, if somebody comes to you and says, we'll let you go if you take this test and prove you're not a sex offender, do not take the test. It's a trap. They don't have level 0 sex offenders. The test cannot prove you are not a sex offender. The only thing it can do is classify you as a level 1, 2, or 3. That's it. Level 1, 2, or 3 in Montana. There is no level 0. You cannot take the test and prove you're not a sex offender because it automatically, the moment you take that test, you are classified as a type of sex offender. He wanted me to ascribe to level 3 rules. And I said, no, I'm not going to sign this. And this is where all this comes up. Sent me back to court. Had a hearing in February of 2010 to modify my conditions. Between February 10th and November 11th, the court ordered me to follow whatever directives Dave Edwards came up with. I was to follow whatever recommendations he had. Remember, I just cited 3 cases: State v. Fields, State v. Hatfield, State v. Hanners. 3 cases right there that forbid what they did. And then 2 years after the decision was issued, I had to wait over 2 additional years for my attorney. My attorney would not file an appeal on it. I had to wait 2 additional years to file an appeal. Filed an appeal in 2014. Of course, unpublished opinion rejected all the arguments. Standard rule. Again, right back to the unpublished opinions issue. They have clear precedent that says what was done in those cases was not allowable. But worse, and this is the point that ropes back around to the subject of this podcast, they didn't have any violations on me. This was not a modification hearing for the purposes of modifying conditions based upon penalty. There was no penalty. This was not a penalty phase of a revocation. They went back for a second sentencing date over 5 years after I had been sentenced because they found they could not violate me with the restrictions they had. And technically it was 6 years. 6 years after I was sentenced, they came back and had a second sentencing hearing and imposed new penalties upon me, new restrictions. Is there a restriction against going to fast food restaurants, against going any place that basically the children congregate? I can't go to parks. I can't go to businesses that solicit children. I can't date a woman that has children, regardless of her age, how old the children are. They could be adults. Doesn't matter. They could have grandchildren. Doesn't matter if they have custody of the kids. Doesn't matter if the kids are alive or not. I mean, it literally is how invasive this is. And I could go on and on with these conditions. But these conditions were added. They were modified. Double jeopardy. And I went to the Supreme Court and I argued this case. And I took it to the United States Supreme Court and argued this case. The United States Supreme Court would not hear it. And of course, the state Supreme Court just suppressed it with an unpublished opinion. And I began to lose my voice. So, I mean, I'm pretty much wrapped up with the subject of my podcast here. At this point in time, I'm just going to rant and rave against how unjust and unfair all this is. But because my voice is going to give out here in a few seconds, I'll go ahead and wrap this up. And thank you for your time for listening. If you like what we do, please support us. The information should be attached to this video. If you do not see it attached to this video, by all means, visit me on YouTube. Look for the Great Montana Conspiracy Podcast. Like and subscribe. The more followers we have, the more subscriptions we have, the more likes we have, the better our circulation. By all means, share it with your friends. If you share it with 10 friends and they share it with 10 friends, we have 100 viewers. It's simple math. So, hey, go out there, do your best. And as I always say at the conclusions of these videos, please be safe, and if at all possible, please be free. Thank you.